For state agency unreviewed decisions, Pennsylvania courts apply issue preclusion when 4 conditions are met. First, the issue determined in the prior action is the same as that in a subsequent action. Second, the party against whom the defense is invoked is identical to or in privity with the party in the first action. Third, the previous judgment is final on the merits. Fourth, the party had a full and fair opportunity to litigate on the merits. Only the first condition is relevant to this dispute. In Pennsylvania, it is unsettled whether issue preclusion applies to findings made in an unemployment compensation hearing. Compare Frederick versus American Hardware Supply Co. Conflicting authority leaves unsettled the question of the issue preclusion or collateral estoppel effect, which should be accorded unemployment compensation referee or board of review findings in subsequent litigation. In Kelly versus TYK Refractories Co., we held the Pennsylvania Supreme Court would not preclude a plaintiff from pursuing a Section 1981 race discrimination claim, even though the UCBR had previously determined plaintiff voluntarily quit. There, a white corporate executive at a Japanese corporation alleged the company discriminated against him in violation of Section 1981. In the first action, the UCBR denied Kelly's unemployment claim, finding he was not discharged, but instead quit voluntarily. In his subsequent federal action, defendants asserted the UCBR determination as a shield to preclude relitigating the nature of Kelly's job termination. We rejected defendants' preclusion arguments because the issue of discharge before the board is not identical to the issue of discharge as presented in Kelly's Section 1981 claim, id. at 1194. Our ruling in Kelly was heard on the Pennsylvania Supreme Court's decision in Odgers versus Commonwealth Unemployment Compensation Board of Review, 514 Pennsylvania 378, 525, refused to give preclusive effect to a UCBR finding in a subsequent wrongful termination case. In the initial action, the Commonwealth Court determined that the Philadelphia Federation of Teachers work stoppage was a strike within the meaning of the Public Employee Relations Act. When an individual teacher subsequently applied for unemployment compensation, the UCBR held the Commonwealth Court's decision precluded the teachers from litigating the nature of their work stoppage under Pennsylvania's Unemployment Compensation Act. The Pennsylvania Supreme Court reversed, finding no issue preclusion because the issue before the lower court under PERA was not the same as that before the UCBR. Under Odgers, reviewing courts must look beyond the superficial similarities between the two issues to the policies behind the two actions. Only where the two actions promote similar policies were the two issues identical for purposes of issue preclusion. Thus, issue preclusion could not apply because PERA primarily benefited the public while the unemployment compensation law principally benefited private individuals. Since Kelly, the Pennsylvania Supreme Court has not spoken on the preclusive effect of UCBR findings in subsequent litigation. Pennsylvania's intermediate appellate courts have issued somewhat contradictory rulings on the subject. The Pennsylvania Superior Court held that an earlier decision of the UCBR denying plaintiffs compensation because of willful misconduct precluded plaintiffs from asserting they had been wrongfully discharged in a subsequent contract claim. At issue was whether discharged employees could assert their employer breached an impelled or implied employment contract by wrongfully discharging them. Without mentioning Odgers and without discussing similar policies and rights that were implicated by the unemployment compensation law and the good cause requirement for employee discharge under contract law, the court found that the UCBR's prior determination that the employees engaged in willful misconduct was the equivalent of good sense permitting discharge in the subsequent contract suit. The Commonwealth
Too fast.
Okay.